Our next panel of the afternoon focuses on troubling litigation trends that have emerged out of technological change. Whether it's the internet, cell phones, the rise of social media, the technology ecosystem has changed quite dramatically over the last 2 decades. But unfortunately, many of our laws have failed to adjust. We're applying standards of liability from the rotary telephone era to today, and this is exposing businesses to costly, unnecessary litigation. This panel is going to focus on these trends. As part of the panel, we're releasing a new ILR paper today on business liability related to workplace social media. Authored by one of our panelists, Sarah Begley, and her colleagues at Reed Smith, the paper discusses how the increase in workplace social media use presents U.S. employers with considerable legal risk under state privacy laws and federal labor law. To moderate the panel, we're pleased to have Greg Silliman, Senior Vice President for Public Policy and Government Affairs at Verizon. Craig has responsibility for Verizon's global public policy and federal legislative and regulatory affairs. Before taking this role, he held several senior positions in Verizon's legal department, including general counsel for Verizon's wireline division. And prior to joining Verizon, Craig was an attorney in private practice here in Washington. So thank you, Craig, for doing this, and we'll let the panel proceed.
Excellent. Thanks very much. And welcome to this afternoon's panel on digital technology and privacy. As you said, I'm Craig Silliman from Verizon, and I'm very pleased and honored to be able to moderate this panel this afternoon. So as all of you know, from our personal and work lives, we have technology deeply embedded in almost everything we do. If there's anyone out there who's been living in a cave for the last 10 years and you don't have technology deeply embedded in your life, talk to me afterwards and we'll set you up with a couple of devices. If you don't have connectivity, we can set you up after the panel with a couple of devices. But I think that to some degree, the technology is so embedded in our lives, particularly communications and internet technologies, that we take it for granted and in some ways forget how quickly this has happened. So just consider, it was just 7 years ago that the first iPhone was released, which really kicked off the smartphone revolution. It was only 8 years ago that Facebook and Twitter opened themselves up to the public. If you go back 20 years, if you were an early adopter, then you probably had dial-up internet with 128 kilobits per second capacity. You may have had a cell phone with analog technology that allowed you to make phone calls. Maybe you had a pager. Right? 20 years ago in the law firm where I was, I got more voicemails every day than I got emails. Right? When you look at that pace of change and we compare it to law and policy look positively glacial in their pace. And unfortunately, that leads to tensions and conflict here because at best, that means that some of the laws that we're talking about, because many of the laws we're dealing with are 20 plus years old. And at best, that means they're just not very relevant today's day and age. But at worst, it means that we have tension, we have friction, and we have opportunities for abuse in the system. So this afternoon, very fortunate to have 3 experts on our panel who are going to talk to us about their experience in these areas where technology and law intersect and sometimes collide, talk about some of the liability risks that gives rise to for all of us in our companies, and then some ideas on how to make things better. So starting from my far end here, Sarah Begley. Sarah is the global practice leader for Reed Smith's Labor and Employment Group. Her practice includes counseling employers on the scope of employment issues and litigating cases involving race, age, disability, gender discrimination, sexual harassment, retaliation, and an individual and collective wage and hour litigation under the Fair Labor Standards Act, as well as state laws. Next down in the middle, we welcome Andrew Mills. Andrew's the head of intellectual property and dispute resolution for Experian. Experian's a leading global information services company that provides data and analytical tools to clients in more than 90 countries. Andrew represents Experian in its membership of the European Justice Forum, a coalition of businesses, individuals, and organizations that are working to promote fair, balanced, transparent, and efficient civil justice laws and systems in Europe. Before joining Experian, Andrew was a partner and the head of intellectual property and technology at Freeth and Cartwright Solicitors, based in Nottingham in the UK. And finally, closest to me, Becca Walquist. Becca is a partner in the Los Angeles office of Snell and Wilmer. She has a wide-ranging, complex commercial litigation practice, including contract and business tort disputes, claims brought under the Telephone Consumer Protection Act, nationwide class action cases, appellate litigation, and commercial arbitrations. Prior to joining Snell and Wilmer, Becca was a partner with Manat, Phelps, and Phillips, and before that, a partner with Kirkland Ellis. So welcome to you all, and Sarah, let me start with you to kick us off.
Okay, terrific. Let me just figure out how to use this technology when, okay, let's see if I'm doing it. The big green button, okay, all right, here we go.
This is a technology panel. We're dazzling you right off the bat.
All right, and the worst is that I represent Verizon, and Craig has already warned me if I screw up, we're done. All right, so I've got to do a good job today, guys. So welcome, I think Craig put it best, welcome to the social media revolution. And truly, that's no exaggeration. The spring uprising in Cairo showed us the power and the efficiency of social media. What we know now is that social media is real, it's a part of our life, and it's something that employers have to harness to get the best of, but also have to be cognizant of what some of the risks are. And so instead of talking about all of the really, really positive things that we know about social media and how it can enhance the brand, build our reputations, spread the word about our products, we also have to be aware of some of the risks. So we'll focus there today. Just a quick survey. Who in the room has a personal device that they use for business purposes? Okay. How about has a business device that they use for personal purposes? Really tricky. We shouldn't, hopefully you didn't film that. All right, so I just want to know, any of you checking Facebook to see if your kid is not going to school and partying at the K Club at University of Wisconsin? Anyone? Anyone? How about whether checking Twitter to see whether your son started last night in a soccer game in Boston? I don't see any hands. Good, that was a test. I'm just making sure I'm the only one stalking my children. But that's what we do. Hopefully not on our business-provided devices. I can tell you there's a guy with a red tie over there that's been checking fantasy football all day. And the truth is, that is okay. All right, so I think years ago when we were talking about social media, it was all, let's clamp down on employees. You know, let's stop them from using our business devices for personal communications. And the truth is, especially with the bring your own device to work policy that many employers utilize and embrace, it just doesn't make sense. So you want to do what you need to do to keep employees, this social media landscape kind of just shows us where we are right now with the ever-growing volume of social media sites. So one really important thing to keep in mind is that social media can build us, social media can destroy us. And so not only are your customers, your clients, but the best and the brightest candidates are out there, and they're looking at your social media and making a decision as to whether you're the kind of company they want to work with. And we know from a human resources perspective that talent is so valuable. So again, social media is out there and we're using it. Social media is also not all that reliable. We know our friend Michael Scott, one of the best managers ever. Wikipedia is the best thing ever. Anyone in the world can write anything they want about any subject, so you know you're getting the best possible information. When you hear HR people talking about, oh, we're going to go online and we're going to check out the Facebook of, a 19, 21-year-old college grad to see if they're going to be the right hire. You have to understand that kids put stuff on Facebook that's not reliable. And we understand, again, in the HR context, the true value of using profile information that's available on the internet. But understand, it is not all reliable. So my suggestion as to, from the recruitment perspective, bring a candidate in, develop their background, see whether they're a good fit, and then have a trained HR person look at internet and profile information just so that they're not in violation of the law. The statistics are pretty compelling in terms of employee use of social media, and that includes using it during the workday, all right? And so here we have 75% of employees access social media using their personal devices at work, and the other 25% aren't telling the truth. Then we have 60% of workers checking personal social media at least once a day. Goes on and on and on. I think what the message is that this is a vibrant method of accessing information and being connected. And I think we all have to understand that this is an ongoing, exploding social phenomenon that we can use and harness to our benefit, but also have to have sufficient policies in place. And that's because some of the stuff on the right-hand side can happen if you don't. So you have, and you can see when you walk around your offices, people that are on social media all day. They're not doing their job, so it's hitting productivity, hitting efficiency. Quality of work might not be so good. But it also exposes employers to liability. And so that's the area where I can tell you, so I'm an employer, I'm an employment lawyer. And in every case, the first thing I do is I get the employee who has sued the company's social media. And most of the time, there's good stuff. Sometimes there's really bad stuff. And that means that the employer or a manager is misusing social media. And in the old days, it was he said, she said. And so many cases were so difficult to really litigate because there was no proof. Today, there's tons of proof. There's more proof than we've ever wanted. So again, having the policy in place is so critical. Social media misused by employees can destroy the brand or really impact negatively the brand. Again, Domino's didn't do anything wrong here. It was those two goofballs who engaged in inappropriate behavior, highly inappropriate behavior on YouTube, where they were, doing a prank and tainting the food and delivering it to customers. Hundreds of millions of dollars of product loss, PR costs, harm to reputation went into solving this problem. And you know what it was? If you look at the picture, that was a bad recruiting decision, right? Employer use of social media, so the people that are paid hundreds of thousands of dollars in PR, they also make mistakes. And these are just some of the examples of mistakes. Kenneth Cole jumped on the Cairo uprising and said that, as you can see, that millions in Cairo are dashing to see the new spring collection. I mean, who would ever approve that type of PR blitz? Kmart, the rest, Urban Outfitters, again, using the storms in the East Coast to say, well, the storms are blowing, but we still have free shipping. So there's liability, right? If an employee abuses social media regarding a coworker, and there's proof, because there's proof, we know nothing's ever deleted from cookies, you as the employer are going to be held responsible if it's employee to employee, if it's during work hours, if it's on your system. So, on a regular basis, employers are forced to fire this group of people. But having the policy in place is so important. So employers, again, using social media to investigate either candidates or employees sets up possible violations of the law. There are privacy laws in more than 28 states that employers could violate if they're improperly accessing information. the NLRA and the NLRB have been so active, and I'm sure you've read the cases, we've written about them in our opinion, but they're really on top of, really for the first time, looking at employers' actions regarding non-union employees and regarding employer policies that would in any way infringe employees' rights to protected rights to act in concert. And what has been some of the cases act in concert? A private chat group trashing the employer. Improper access resulted in liability for the company. They even said, where they have in many businesses, no photographs, no surveillance may be taken by employees. There's a case that says, selfies are fine because it kind of shows employee association. So any kind of activity where an employee could allege that they're coming together with other employees to discuss wages, hours, conditions of work, including trashing the boss, is fine. And so this has been a huge development for employers. So have a policy in place and get consent. You need consent because there's all kinds of laws that say if you don't have consent, you're violating the law. Understand the law and only protect what you need to protect. Don't have an overly broad, and that's one of the things the NLRB has warned employers. What is it that you're trying to protect and why? That's what your policy should state. These are the various laws that you could violate as an employer by improperly searching and accessing employee social media, and then implement a well-drafted, well-communicated policy. So that's my spiel.
Excellent, thanks. And I want to tell you, I've been monitoring the ILR Summit hashtag in real time. This is a very well-behaved group. There's nothing outrageous taking place on their employer-owned devices as you're speaking. No good selfies even, but so you've clearly scared them straight. So very, very good.
I haven't seen any. Thank you.
So thanks. So Andrew, a lot going on in the social media, the search engine world across the pond. Lots of interesting issues being grappled with in Europe. So give us your perspective about what's happening and what's on your mind from a European perspective.
So before I start, I thought I'd just say one little thing. The first session this morning was about lawyers behaving badly. Okay, so this is a different the different world that sometimes we live in. Part of my legal qualification is as a notary. It's quite hard to become a notary in the UK, and our regulator is called the Faculty Office, and that is part of the Archbishop of Canterbury's office. So here I am. I'm regulated partly by a clergyman. I'm an atheist as well.
Maybe you can tell us what the sanctions are, because I can imagine those are quite overwhelming.
They can strike me off. Okay, so I'm guessing that most of you perhaps aren't experts in the state of play in the European Union, so I just thought I'd give you a quick overview. So it's just to remind you, we've got 28 countries in the European Union and a population of 503 million people, and we've had legislation about data protection for 30 years. But there's been a lot of development, as we just heard, over the last few years, and there's been a big drive to try and update our privacy legislation. And this has been pushed by the European Commission, which is the executive body of the European Union. And they proposed some changes a couple of years ago, and it's been heavily, heavily debated. Now, there's a big political push to get this sorted in 2015. I'm not sure it's going to happen, but the Commission proposed a package of proposals, and this comprised a directive and a regulation. Now, these may be meaningless terms to you, but just to give you an oversight, a directive is something that is kind of a minimum standard. The European Union says this is what every country has to implement, and they have to implement that in national law. However, a regulation, once it's approved, becomes law throughout the whole EU. So we've had 30 years of directives on data protection, and that's resulted in different implementations in different countries. And now what's being proposed is a regulation to try and harmonise across the whole EU the position on data protection. Now, there's been a whole range of concerns here, and lots of industries are worried about this. Everything from finance, insurance, credit referencing, marketing, archiving, social media companies, retail, medical. And in the main regulation that's been proposed, 91 articles, there were 4,000 amendments proposed by the European Parliament. So it's a pretty contentious piece of legislation. It's of wide interest to parties outside of the EU because of the nature of that massive trading bloc of countries. And there's a close relationship between companies in the EU and the US. And so the ILR, for example, has been very interested in a lot of these proposals. And the new laws will potentially have much wider effects than the current regimes. And, for example, there's a new proposal that's going to deal with use of personal data in criminal and justice investigations, which is kind of a new step. There used to be one standard for everyone before. There's a whole load of new issues that have come out. So you might have heard about this right to be forgotten. So there is actually a proposal in the legislation that has come from social media, people being concerned that they put stuff out when they're that 20-year-old and then they can't ever take it away. So there's proposals for that, but that's been highlighted also by some litigation about Google and people trying to get stuff removed from the internet. This is about existing rights already, but that litigation has taken, it's kind of informed the debate about what should happen now. And then we've got big political divides going on. We've got a European election that happened earlier this year. The political landscape of the European Parliament has changed. We've got a new commission that's about to change, and that's becoming a lot more political. So we've still got a number of big problems going on. We're not sure about the legal mechanism that's going to come out. We've got this concern about the right to be forgotten. We've got concerns about automated processing and profiling. So, for example, people are often concerned about behavioural adverts. You know, you go from one website to the next and the same kind of adverts are popping up. So there's concern about that. But automatic profiling is also used for credit applications and credit scoring, and that's a different sort of implication, whereas the stuff's drafted very, very broadly. And then lastly, at this stage, I think I'm going to come back to in a bit, Craig. There's a concern about companies that are operating in Europe. I know they're going to have to deal with 28 separate regulators. And so there is a proposal that you should deal with one regulator in your main kind of place of business in Europe. But again, that's fraught with problems. So that's kind of where we are at the moment. A lot of uncertainty, but a lot of change coming.
That's perfect. Thank you, Andrew. Great overview and a lot to come back to here in a minute. So Becca, let's turn to you and some of what you've seen watching the TCPA.
Well, it's getting uglier. I was here last year, if some of you were here, talking about the TCPA, Telephone Consumer Protection Act, which has become, and in the last year, become even more the basis of it's the most filed lawsuit right now in federal courts, class actions under the TCPA and TCPA lawsuits. The reason for this is it's a 1991 statute, so we're talking about 24 years ago. That's the last time Congress touched it. They've never amended it. They've never come back into it. It was written with technology at the time of 1991. It was written to stop random and sequential telemarketing, where there were these machines, these auto-dialing machines that telemarketers were using that would just go through every number in the phone book, or that would just randomly put numbers together and try to reach out. And so the worst part of the TCPA for us now is the part that was written to address that random and sequentially dialing telemarketing. And because you would never do something like that with good faith or thinking you had somebody's consent to call, there's nothing built into the statute for affirmative defenses or anything on that portion of the statute that dealt with auto-dialing. The other part of the statute dealt with do not call. That's not where we see so many litigations, because do not call has affirmative defenses, has other things built in that companies can use. But fast forward 25 years from when the statute, well, approximately 25 years from when it was entered, and now we have companies that have computers that are claimed by plaintiffs' lawyers to be auto-dialers because you could technically program them to randomly and sequentially dial, even though you're not doing that. We have smartphones, we have texts that didn't exist before, and the courts have said, okay, a text is just a call, so we'll hold it, to the same standard. And you have this statute that for the first 20 years it was around, you really didn't see that much play under it, and now it is just funding the plaintiff's bar because it's uncapped statutory damages. So I don't need to show any actual damages. I get a phone call, I didn't consent to have it, I'm gonna say it was auto-dialed, I got it on my cell phone, and so now I can be the plaintiff in a class action lawsuit. And you have these firms across the country, plaintiffs' law firms, that are joining together. I have some suits I'm defending that have 7 and 8 different law firms. They pool together, share the costs, and go after essentially every deep pocket company in America. And now they're doing it under vicarious liability theories. So you're not even the company that called, you're a cruise line, but some travel agent called selling your product, and now you're facing a nationwide class action lawsuit. And because you don't have to have actual damages, and because the statute was never intended to do any of this, there's no damages cap. So you get 10,000 calls, that's $5 million. Most of the lawsuits I'm involved in, if you actually added up the number of calls that are made by a legitimate company with millions of customers, you're talking billions of dollars of statutory damages. And that's why these things have started settling at really high rates, because companies just can't look at these statutory damages. And can you pass that to me, Andrew? So what has happened, and in the last year it's become really egregious, is a whole new form of ambulance chasing that's taking place to get your TCPA plaintiff so that you can go for your lottery ticket and grab the golden ring and get your money. We've always seen solicitation letters, but now they're so targeted that there's a plaintiff's law firm that does a lot of the fax litigations. They have, I believe, 126 nationwide class actions under fax statutes right now. And the way they got all their plaintiffs was they had one class action where they got the list of everyone who had received a fax. It was 10,000 people in a targeted fax, little mom and pop store that had no idea that faxing had any laws that regulated it. And then they sent a letter to every company in that saying, are you sick of getting faxes? Let us know, we can help you get $1,500 per fax. They have companies that just have them routed in. The law firm is actually a recipient and can go into the fax server and just flip through every fax the company is getting to look for anything they could maybe tie to a deep pocket. I was in a deposition recently with someone who says he's sent that law firm over 1,000 faxes. He just takes every single one his fax machine gets, sends it to them so they can look through and try to find someone to sue. And they're suing on vicarious liability. They're not suing who brought the fax, but if they have a fax, I mean, one argument I make all the time is you could get a pizza menu that has a Coca-Cola drink advertised on it, and these guys would sue Coke, saying that you benefit from that fax. Emails, it's so funny because once you litigate against some of these guys and you're in their email address book, you start getting the emails they send regularly to everyone they've ever had contact with saying, are you getting a robocall? If so, you can make money. Targeted websites are really fun for a lot of companies. If you go and type in, collections calls and your company's name, you should not be surprised to find a law firm that has put up a website saying, are you getting collection calls from X company? If you are, here's what to do to make money. And then they say, step 1, hire my firm. Step 2, and then they go through a little thing so that you can generate a lawsuit off of that. Social media is also being used. Recently, there was a class action certification process where somebody had challenged the plaintiff's attorney saying, look, you just got your receptionist to go on her Facebook and send out some blast stuff to her friends to get somebody to come and be your plaintiff. And can that really be appropriate? And the court had said that was okay, which is silly. So they're using Facebook to reach out to people. Bankruptcy proceedings are a really fun one. There's some attorneys in Florida in particular that go into the creditor's exams. And then during the creditor exam, here's your bankrupting person, as they ask about what you owed each creditor, they say, and did that creditor call you? And when they called you, did they have your permission to call? And then they will, out of that bankruptcy proceeding or in it, file TCPA actions against every creditor. And a lot of this is without the concern of whether or not the calls, the text, the faxes actually violated the law, because it's all about as long as you have enough that you can say happened, you can get companies to settle with you. My favorite one is this new app. When I say favorite, it just drove me crazy. It's brand new. It's the most, he touts himself as being the attorney who's filed the most actions every year since 2011. And he's moved into TCPA because that's just where all the money is. There's no cap on damages. And he's now created an app that people can download on their phone that feeds data directly to his law offices so they can go through every phone number of every call that that person receives to see if they can bring a lawsuit. So I did bring a couple examples of, here's an internet solicitation, you know, and these things, they pay for them to go up high on the Google searches so that when you're searching for do not call, you're gonna find something, you know, stop telephone harassment or robocalls. It promises essentially that you're gonna get $1,500 for a call. All you have to do is put in the phone number right there, and they have their database. They know every company that has paid settlements. They know everybody who is likely to settle with them or that they want to sue. And you put in the phone number and they'll immediately tell you, oh, you know, that's Dish Network, or oh, this is Verizon. And then they invite you to send them a form so they can represent you in court. And this is why the litigations are just exploding. Another example, you have a lot of firms that just list, here's all the companies that we sue. I'm sorry if some of your companies are on this list. Maybe it's too small, so you don't have to read it, but they're like, sue a bank, and then they list all the banks that they'll bring suits against. You know, sue a restaurant, sue a this, sue a that, and they, you know, you're supposed to go down and look and see if one of your calls has come from someone. So, you know, it's crazy there. And then here's the app, and I hope none of you go home and put this on your phone. I'm gonna be so disappointed in you as a human being if you do. But it's the Block Calls Get Cash app. Because people are now bringing these TCPA lawsuits without even receiving the calls. They have call blockers to block any phone call that they don't recognize. But then they use that as a log to create the list of here's all the phone calls I got. And then they bring a lawsuit and you try to say, but it didn't even go through to your phone. It's in the call blocker. And they say the invasion of privacy happened when you tried to reach me. So we have these fights. But on this app, and I just love, I actually brought two versions of this website because the pictures changed and I couldn't pick between them. This one is the girl going, control your phone, you know, block calls, nail harassers, get $1,500 per call, laugh all the way to the bank. You know. And then the second one is her with her money, you know, nothing to lose, everything to gain, and again, the $1,500, because they do this all on contingency fee, and they're just out there. Essentially, if you have a company that is calling people, sending any sort of text, faxing, I mean, one of the biggest issues right now with TCPA is you think you're reaching your own customer, but maybe the customer dropped their phone number, someone else has picked it up, so you're actually ending up accidentally calling someone new. And ILR has been great with this. They've been meeting with the FCC. We're hoping to get the FCC to give some clarity there that, you know, this shouldn't just be a strict liability statute. I think the best example of that is the pending Rubio's petition, where a Rubio's manager lost his cell phone, but he was getting food safety texts anytime something happened at one of the restaurants. Somebody else got assigned the number and started getting those texts, and then waited till they had 876 of them come through, then brought a lawsuit of what would be $400,000 of damages under the statute, you know, against Rubio's. And this is for calls that were intended to go to their own manager. You know, it's this kind of stuff that is really ratcheting up under TCPA.
Thanks, Beckett. So I'm feeling great. All the millennials in my company are using their company-owned devices to do social media all day and create massive liability for me. I was already worried about safe harbor and binding corporate agreements and all that. Now it's going to get a lot more complicated in Europe. And basically, I'm faced with uncapped liabilities for no damage done. So this is great. With no statute of limitations as well. That's right. So we're feeling really good here. So let's talk about where this goes from here and how we protect ourselves a little bit. And Sarah, when you look at the world of social media, and you talked about having a policy. So, you know, many companies have policies going back for media communications and things like that. You know, can you kind of just dust this off and spruce it up a little bit for the new world of social media? And social media changes so quickly. As best I can tell, the sort of rule is as quickly as we as parents can get on one social media platform, then immediately another one crops up for our kids to move to so that we can't see them. You know, can the law, you know, in a common law jurisdiction where we're basing things on precedent, can the law keep up with this, and how as we as companies get policies in place to protect ourselves?
All right, so just one thing that in terms of who's using social media, 45 to 50-year-olds are the fastest growing Facebook users. So kids aren't using Facebook anymore. We're like, you know, falling behind, but I'm really in the next group. And the 50 to 60-year-olds are the fastest growing Twitter users. So, you know, this is a new world. With respect to policies, you know, we have electronic use policies, and they've been in place for 10 years. And I think what you need and what the NLRB has warned us about is, what are you looking to protect and why? So long as you're looking to protect your employees, your customers, the policies that you have in place that might otherwise be impacted, your proprietary information, you're going to be fine. If you're looking to go after employees who are engaging in concerted activity or anything that could be construed as concerted activity, which is, I'm looking at my colleague over there, Joel Barris, who's written every blog and article about the activists NLRB. The NLRB is going to come against you and come against your policy. So I think it's a pretty simple policy. It's a policy that says, one, you give consent, employee, for us to monitor your use of our equipment. To the extent that it is a personal device, most employers have a BYOD policy, bring your own device to work policy, that limits the employee's ability to use that device that would do anything unlawful. And so some of the areas that pop up that employers need to be concerned with are anti-discrimination and harassment issues that are all covered by the EEOC. So you're not going to use our device, and you're not going to use your personal device to communicate anything that would be discriminatory, harassing, or against the law. The other area that is not talked about so much is protecting proprietary information. And this is where social media allows employees to go in these private chat rooms and talk about the products and trash the employer. And so it's really critical. Everybody, public employees have a First Amendment right. Private employees don't really have a First Amendment right, which I think is surprising. But you have to give employees very, very strict instruction that they're not to be sharing, disclosing, discussing proprietary information. Now, the NLRB has said employee information as to wages and things like that, that's protected concerted activity. You know, we'll see where that goes. So really critical to have a simple policy in place, have the employee acknowledge that they consent to the terms, that the employee should use the device to the extent that it's being used for business, only for business purposes, and to the extent that there is a violation of the policy, there will be strict enforcement of appropriate discipline. So it's really not that, I mean, you can dust off really, really easily your 10-year-old policy, but you've got to put social media in there.
All right, thanks, Sarah. You know, Andrew, fascinating time. You touched on some of the things going on in Europe right now, the recent parliamentary elections, new commission coming in place. There are also a lot of other things going on, everything from the Snowden revelations, which has put a lot of focus on data, the fact that many of the big web companies are US-based, often have servers in the US, and so a lot of questions about data flowing. But then also we live in a world where it's not just web companies, social media companies, manufacturing companies have huge amounts of data for just-in-time manufacturing, anything else going around. As a global company, so how do you think about this? Where do you see this going in Europe, and how do you begin to grapple with all that's going on as the directive is debated? Much more serious potential fines on the table, much more serious issues around how you manage your business, especially if you're data-based. How do you see this playing out in Europe, and how do you see this being managed for a company, a global company in particular?
So what we see, I think, is a great challenge here, because you know, there are certain global trends, you know, it's sort of a global trend. Privacy is a much bigger issue globally. Consumer protection is a much bigger issue globally, but the way these things are implemented is very different. And what's pretty clear is you can't have a one-size-fits-all model. You know, we've got some big kind of political and cultural clashes here. I mean, just listening to what you're saying, I mean, the biggest fundamental thing I would say is that the approach to data privacy in Europe is fundamentally different, because I'm going to quote here from Viviane Reding, who was an outgoing commissioner, and she said, "I warn against bringing data protection to the trade talks." This is to the US. "Data protection is not red tape or a tariff. It's a fundamental right, and as such is not negotiable." Europe sees data protection and data privacy as a human right. It's akin to, you can't torture people. So that, you know, that's a pretty big thing. The other big thing that we see is you know, the European approach is horizontal. It cuts across all businesses. It says you've got to use data about people in this way, and here you've got a much more sectoral approach, and you know they create challenges. The other big issue, I think, is, you know, the way that some stuff's coming together. So we've already heard today about you know, different regulators having enormous powers. You know, we're seeing some of those things come to Europe, and we're seeing, you know, the potential, as you mentioned, for huge fines from, you know, data protection authorities under the new regime, potentially 10% of worldwide turnover. You know, we're into kind of antitrust type penalties here without necessarily the clarity as to how they're got to in the same way. We're seeing the potential in this stuff maybe for something akin to class actions, even brought by consumer associations where there's no one that's complained. So, you know, there's kind of some stuff that's starting to look together, and I think if you're a global business, you've got to be concerned about what's happening everywhere, because, you know, there are patterns and trends, and, you know, lots of things can come together to make, you know, to create an environment for that, you know, a plaintiff bar environment to happen. So I think you just have to watch. You've got to take the lessons of stuff that's bad, and you've got to try and influence where you can.
Can I just add to that? So from an American perspective, if we think an employee is engaged in some kind of inappropriate communications with another employee on their personal device, we have the right to ask the employee to turn over that information. In the EU, both in that context and in the context of conducting an internal investigation in the employment context, there are really rigid laws that prevent global employers from accessing employees' communications, even if we would consider them violations of the law, and even if it's employee to employee or employee to manager. So that's where, as our title for today, that's where our worlds collide.
Yeah, and the problem is that varies from country to country.
It
Europe
does.
at the minute.
It does.
So a classic example, you know, you've got a global system. You want a global, global company. You want an HR system that you can use all around the world, the same platform. If you've got your employees in Germany, the data can't come outside Germany. You know, you've got to have different servers that sit there just for that. You know, and it's that kind of stuff that creates the clashes.
Yeah, and I would add, it may not even be a matter of just interpreting local law, but actually negotiating it with the local works council in terms of what sort of access you have. And so it really adds a level of complexity. That's what makes it fun to be global, I suppose. Becky, when you talk about TCPA, I don't know that you use your words, I'll paraphrase, which is, this is nuts, right? So if you were queen for a day, you could just change it. What if you could come in and actually change the law in some way? Is there an easy fix that could be recommended to policymakers? Recommending, you know, we don't get to just have it the way we want as companies, but recognizing there is a balance here, right? Policymakers were trying to solve a problem 24 years ago. It may not be well suited for today's world. What's the right fix here? What's the right balance?
Well, and I did a few slides on this. I think there's a few different approaches, all of which are being put into play. I know that, again, the Chamber and ILR are talking to various people here because this is just getting so out of control. And we're just getting flooded with lawsuits. There have been a couple big settlements, and the second the Capital One settlement at $75 million went through, I had another 5 or 6 additional lawsuits brought against clients of mine, like within that next week, because it's just the money is looking so good now. And nobody takes these to trial. I'm not aware of a single case with, 2 million or 3 million alleged violations that have gone to trial, because the damages are so enormous that nobody will play that game. So they're just settling, and the plaintiff's bar is getting very wealthy off of it. So there's some legislative fixes that Congress could do. Right now, everything is just in the hands of the FCC, who is backlogged with petitions. They're just barely making headway on some of those, and it really shouldn't be up to the FCC to rewrite this old statute. So the first one that really should come into play is the affirmative defenses. They're there for the second part of the TCPA about do not call. For the first part of the TCPA on these auto-dialed calls, especially to cell phones, remember cell phones did exist in 1991, and that's why the TCPA has all this special protection saying any auto-dialed call to a cell phone should be a problem, not just telemarketing. But a cell phone in 1991 was a giant, big, expensive box where everything going into it cost a fortune, and you had to put it on your backpack battery power thing. I mean, it wasn't what we have now. So the fact that there's no affirmative defenses for well-intentioned companies in the first part of the statute is a big problem. So if you get out of the strict liability, if you can have, we're not talking about telemarketers who are randomly sequentially dialed, so there should be affirmative defenses about having policies and procedures to comply so that one mistake doesn't land you in a class action setting. Then there's ambiguous terms that are being exploited by the plaintiff's bar that were written, again, at a time of different technology. So rather than just leaving it up to the FCC to keep coming out and saying we think this is what it means, really there should be a legislative fix to this. Who's the called party who can sue? Was it the person? So we have situations where a roommate gave her roommate's phone number, and so when her roommate gets the call, from the company that thinks that they're calling the person who signed up, then they're finding themselves subject to multiple lawsuits by not just the roommate but the original person fighting about which one of them gets to have this lawsuit. Who is the called party, and can the called party be the intended recipient until a company knows better? Because we have companies that are sending out messages like, hey, there's a storm in your area, here's an automated message or a pre-recorded call to everyone, finding themselves getting sued by the person who's not their customer when they were intending to reach the customer at the number that they'd had for that customer. I mean, it's crazy stuff. Capacity, what is the capacity? Auto dial, all it says about auto dialer in the TCPA is it's something that has the capacity to randomly and sequentially dial, and that has led to more fights than anything. Does that mean how it's being used now, which is what I would say is the rational explanation? But the plaintiff's bar has pushed that it's a hypothetical future capacity. As long as you could program something to randomly sequentially dial, it's an auto dialer, in which case every cell phone that we all have are auto dialers, and we're violating the TCPA all the time. On behalf of is a really problematic one, because the FCC did issue a ruling about 1.5 years ago saying a call is made on a company's behalf, under federal law of agency. So that part's good. If you hire someone as your agent to make a call, you're responsible. But then they threw in, just almost as an aside, but also you could have affirmation and ratification as reasons that it's on your behalf. And so we find so many companies right now being sued on arguments that they somehow would financially benefit from a telephone call that they didn't make, didn't authorize, and had nothing to do with. So if they can look at that, if they can put, I think this is the big one, if they could get a damages cap, there is not another consumer protection statute that exists under federal law that doesn't have a damages cap. So you have the Fair Debt Collection Practices Act, which lets you have up to, I think it's $1,000 plus your reasonable attorney's fees for a class action, $1 million. That's why nobody's bringing those anymore, because they don't want only that money under Fair Debt Collection Practices Act. So they take collection calls and they bring a TCPA action saying every call violated the TCPA and give me my $1 billion. So if we could get a damages cap in place that's just like the other statutes, that would really work to stem the tide. Also, there was no statute of limitations in the TCPA, which again was never intended. You should see the description of it on the floor of the Senate when it was passed with no debate, where someone said, hey, I hope this makes it really, the $500 per call, that's to make it worthwhile to the consumer to go into court, preferably small claims court. And then it's going to be fair to the consumer to go do that. They weren't thinking about these kinds of class actions that exist now. And with no statute of limitations, the courts have just imposed a 4-year statute. So every company, I've seen cases brought 3 years and 10 months after a text was received by somebody who ran into a TCPA plaintiff's lawyer, somehow went back through all their old texts, found one, and then said, now I'm going to sue, and we get all 4 years worth of anything you've ever sent, and we don't want just the data for this, we want every call and every communication you've ever had so we can go through and look for more plaintiffs. It's crazy. And then finally, they should consider the new technologies that exist and how should the TCPA even apply to a text message? They're being treated like phone calls under the TCPA when really, they're kind of more like emails, which do not have these types of restrictions. With faxes, when we're defending fax suits, we keep trying to mention to courts, most of whom are very old and don't maybe understand the technology as much. But you're not getting them often in fax machines anymore. They're coming in as email, often as email that goes right to your spam filter. And is that really an actionable, TCPA communication if something went to a spam filter in your email? And then new applications. GroupMe found itself immediately getting sued. That's where I can put in 10 phone numbers of my friends and send a group text to all of them. We all respond back and forth. And if somebody accidentally has a wrong number in there, which happened to me, it's so funny, I'm the TCPA person, and I got added into this frat boy GroupMe group. And it was so disgusting, the stuff that they were texting back and forth to each other, and I'm just like, get me out.
Did you sue?
I did not sue. I can see why maybe for that one I wanted to warn women generally about these guys, but all I had were their nicknames. But GroupMe found itself getting sued for that as TCPA violations because they didn't have people's consent before those were getting sent. Somebody just came up with a new technology with phones to walkie-talkie back and forth, having no idea they would then get sued under the TCPA. So it's something that really needs to be considered. You can't have a statute about technology that hasn't been looked at in 24 years.
Right. Thanks, Becky. You can hold to that. Okay, I have a few more questions, but I want to open it up to the floor to give others a chance. And while people are looking for microphones, I just want to showing that we are using technology in real time. I just want to do a shout out to the ILR tweeter who's thanked me for modeling this panel. I assume that meant moderating, but thank you. This is about as racy as we get at ILR, ladies and gentlemen. You gotta take what you got. Do we have any questions on the floor here? No. Okay, then I want to use chair's privilege. So this is an area, we've talked about social media, we talk about, even you're talking about, Becca, some of these new applications, the GroupMes and whatnot. And Andrew, we talked through all the things that are going on in new data flows. This whole area is changing so quickly. So if you look out over the next 5 years, is there going to be a time where you sit up here and say, all right, we've got clear guidance, here's how you handle the new world of technology and data? Or is this a world that we all have to reconcile ourselves that we're always going to be living in a bit of ambiguity because the technology is always going to outrun the case law and the policy on this? And we open it up to any of you who want to jump in on that.
I think the challenge we've got is that we just don't know what's coming. And if you look at some of the applications you can have on your phone now, even a year ago, some of those things weren't imaginable, and I think that's the difficulty. There is something, I think, in kind of the European approach to saying, you treat it about personal privacy and your data, and then it doesn't matter what comes along, but that doesn't really necessarily answer the problem either. So I think we're going to be in a never-ending situation here, but I'm not sure what the answer is.
I think from an employment law perspective, we're always going to be playing catch up because the technology is just, bombarding us. But I also think we're in a different position than we were 10 years ago, and that corporations and employers are embracing technology. And for the most part, employment law is pretty simple. Be practical, don't violate the law, and use common sense. And that has been, our foundation for recommending different courses of action to employers for years and years and years, and that'll stay our type of guidance to employers. Just be practical,
Don't you think the nature of work's changing? I mean,
oh, no question. The nature of work is changing.
I don't know if you heard that quote. Work is what I do, not where I go.
Yeah.
And that is, they're going to have a massive influence on technology and employment and privacy and everything.
And I think it's not where you go anymore, because most employers, or many employers, are looking for employees to be both mobile and to also be remote, because there's tremendous cost savings and it's a global world. So I totally agree with them.
Right. Thank you. With that, and again, showing the speed of technology, we got started a little late, so I'm going to yield back 5 minutes to the request of our ILR folks. And so with that, let me please join me in thanking our fantastic panelists here. Thank you very much.